Good evening, ladies and gentlemen. You're all very welcome. My name is Jerry Monaghan. I'm the Ireland country representative of the DRBF, the Dispute Resolution Board Foundation. We're just waiting on the participants to join. I can see the numbers rising as we speak, so I might just give it a minute or two before I formally kick off proceedings. If that's okay. Right. I hope everybody can hear me. I presume you can. Thank you. Okay, well, I see the numbers are increasing there. So look, we'll formally kick off. And good evening all, you're all very welcome. My name, to those that don't know me, is Jerry Monaghan, as I've mentioned. And since January of this year, I've been the Ireland country representative for the DRBF, the Dispute Resolution Board Foundation. It's an organization that's established to promote the use and efficiency of dispute boards, particularly in terms of dispute avoidance around the world. It's been in operation for some 30 years. Dispute resolution is very much in vogue at the moment, as we all know, in terms of efficient infrastructure delivery. And when I sat down in January with my colleagues at the DRBF to kind of consider how we might start a series of events for Ireland, for an Irish audience, you know, we were kind of conscious of the fact that there's varying degrees of knowledge as towards dispute avoidance, dispute boards in the Irish market, varying from very considerable experience and comprehensive experience on one end of the spectrum to maybe lesser so on the other end of the spectrum. And of course, in the middle then is the whole process of standing conciliation, which is a uniquely Irish approach to dispute management and dispute resolution, which we'll touch upon this evening. I'm glad to say that we have over almost 200 registered attendees, which is brilliant, and you're all very welcome. When I looked at the attendee list this afternoon, I'm estimating about 70 to 75% are from an Irish audience, and maybe the balance from an international, various parts of the world. So you're all very welcome. I mention that really to keep myself and our speakers advised as to when we're talking about dispute resolution practices, procedures that are uniquely Irish, such as conciliation or standing conciliation, that we need to maybe bear in mind that not all of our audience will be as familiar as others with it. Just in terms of logistics then, you'll see on your screen a Q&A button and a chat button. The chat button really is for comments and to say hello if you so wish. The Q&A then is obviously, as the name suggests, is to allow questions to be posed to the panelists and to myself as we go along. Before I introduce the speakers, and we've some leading global experts in the practice and operation of dispute boards with us tonight, before I introduce them formally to you, I just wanted to hand over to Ms. Anne Russo, who's the Executive Director of the DRBF, to kind of say hello and welcome you in the first instance, and to touch upon some of the benefits of membership and the DRBF in general. So Anne.
Very good. Thank you very much. It's a pleasure to be here with you all today. The DRBF, as he mentioned, has been around for quite some time. We're celebrating our 25th anniversary this year. And the DRBF was founded by some of the original founders of the dispute board process. The DB process has been in operation for over 40 years, started on a tunnel job in Colorado in the 1970s. And so we really have a very rich backlog of experience, and that's what the DRBF's organization is all about, sharing those best practices, talking about how the process can be used efficiently and effectively around the globe. And so it's wonderful to come today to talk about the process and its prospects in Ireland and share those ideas and experiences that may be useful to attendees who are signing in from other countries as well. The DRBF is a membership organization, and you can learn more at drb.org. I'll pop that in the chat later today. We are recording today's session, and it will be one of the items that you'll be able to find in the DRBF's membership-only library. This is a resource with hundreds of papers, presentations, videos, and other educational and reference materials that members find useful as they're both promoting the dispute board practice and applying those techniques and skills, whether they're serving as a party representative or a dispute board member. Membership has other benefits as well. We have a conference next week, and we always have member pricing for conferences and training workshops. We have some programs like a mentorship program that's kicking off for our international members. So there's lots of interesting activities and resources available to members. One thing that if you're a non-member, you might want to check out when you go to the membership page, you can sign up for a free 2-week trial. And that's an opportunity for you to access the full functionality of our website, go into the members only section, and learn a little bit more about membership in hopes that you will join us. So that's the end of that. But of course, I'm available to field any questions. I'll put that contact information in the chat as well, and would encourage you to reach out if there's anything I can do to help. In the meantime, Gerard joins a very robust group of country representatives around the globe. So also on our website, you can find people that may be in your country if you're not in Ireland, and reach out to them and find out about the activities and implementation of dispute boards in your home country. So I'll turn it back to you, Jerry.
Thank you very much, Anne. That's fantastic, and thank you for that. Okay, so I'll proceed now to the main topic of the evening, and it's a review of dispute boards from an Irish perspective, and looking at the theory and practice behind them. With 2 global experts this evening, as I mentioned, Miss Aisha Nadir, Aisha and Dr. Niall Bunny, neither of whom I'm sure will need much of an introduction to our attendees, but in time-honored fashion, I'll give a brief introduction nonetheless. I mean, Aisha is a mediator, arbitrator, and dispute board member. She's over 30 years experience in procurement and contract management of a range of infrastructure projects around the world. Aisha has sat as a member of the FIDIC board and the FIDIC executive committee, and she chaired the procurement policy unit for FIDIC over the years. She's also on the ICC standing committee on ADR, to mention a few highlights in her bio. Dr. Niall Bunny is a chartered engineer, a registered chartered arbitrator, conciliator, mediator, and adjudicator. As a visiting professor in construction law and contract administration at Trinity College in Dublin. Dr. Bunny has practiced since 1972 as an arbitrator, conciliator, mediator, or DAB member on cases involving parties from over 50 jurisdictions. He has won numerous awards, professional awards for his work in engineering design and dispute resolution. Just to mention one, I mentioned in 2018, he is awarded the FIDIC Prangi Award for very significant service to FIDIC and the consulting engineering industry over the previous 25 years. So that's a brief introduction to our 2 speakers. There's going to be 3 elements to the discussion tonight. Initially, Dr. Bunny is going to introduce the topic of dispute boards and dispute avoidance with an Ireland dimension to it, an Irish market dimension to it. And then Aisha is going to pick up on the theory and the practice and looking at the practical issues around dispute boards, again, with a view to the Irish market. After that, then we'll have a roundtable discussion in terms of the issues that have arisen, and we can begin some Q&A topics that arise from our participants. So with that, I hand over initially to Dr. Niall Bunny. Niall.
Thank you, Jared, for that introduction. And good evening, ladies and gentlemen. My topic really is the use and misuse of dispute avoidance. I'm concentrating on dispute avoidance. Dispute adjudication boards were developed by FIDIC following the successful American experience of dispute review boards, and first appeared in the 1995 Orange Book for Design, Build, and Turnkey projects. The board's function of review was changed to adjudication by FIDIC in order to simulate the engineer's determination or decision under the earlier editions of the FIDIC contract. Following the successful use of dispute adjudication boards, which I will now refer to as DABs, in the Orange Book, the function of a DAB was incorporated into the 1999 red, yellow, and silver forms of contract. However, in the Red Book, a standing DAB was provided for, which related to a DAB being appointed for the duration of the entire project, whereas in the yellow and silver books, an ad hoc DAB was provided for, which related to a DAB being appointed only after dispute had arisen. The idea of the ad hoc DAB was proven to be a mistake and was subsequently abandoned in the 2017 editions of the FIDIC forms. In Ireland, the first contract using the 1999 FIDIC Yellow Book, and thus DAB, was the Dublin Light Rail project, or short, it is now referred to as the Lewis. Although this contract used the Yellow Book, which provided for ad hoc DAB, the employer's lawyers, I should say, had identified the mistake of using an ad hoc DAB and instead changed that to a standing DAB. And so it was incorporated in this project. The project was designed as a fast public transport system for part of the south of Dublin City, and construction on the project commenced at the end of 2001, with the works being completed in September 2004. It had 9 main contractors, and the employer was known as the Railway Procurement Agency, known as the RPA. I was appointed as the sole standing DAB for the duration of the project. By the time it was completed, most of the problems faced were solved around the discussion table, and only 2 disputes were referred to a full adjudication process by the DAB. Arbitration was therefore not required to resolve any of the disputes that arose. This project was taken into a second stage in February 2007, where the rail network was extended to parts of the city center. The employer continued to be the RPA, and this second stage had only 5 main contractors. Again, the same form of FIDIC contract was used, and I was once again appointed as a sole standing DAB. The second stage of this project was completed in March 2011. The combined cost of the 2 stages of this project was over 700 million euros, and once again, all the problems that arose were resolved through discussions, and an arbitration was not needed to solve any of the disputes that had arisen. During 2016 and 2017, the Irish government had formed a committee. Sorry, I should have said during 2006, 2007, the Irish government had formed a committee to adopt the use of the FIDIC contracts in Ireland for construction projects. This was partly as a result of the success of avoiding arbitration in the Lewis project. We were just nearing the end of our work when the Irish construction industry was dealt a significant blow. The committee was disbanded, and we were informed that the relevant authorities had decided to use a new form of contract, which was later named as the Public Works contract. I would now like to turn to a recent article by Mr. John Farage O'Brien, which was published, fortunately for me, in preparing this presentation. It was published last month, published in the Construction News on 3rd February 2021. Mr. O'Brien is a prominent construction consultant in Ireland. And in his article, he lucidly explains the adverse effects of the public works contract on the Irish construction contract scene, which combined with two other events he referred to and called them the perfect storm. The first version of the public works contract was introduced in 2007 to replace the GDLA and the IEI forms of contract when, as Mr. O'Brien articulates, driven by a cost-saving effort, he called it a politician's brief, was developed. However, Mr. O'Brien explains that what many politicians at the time did not understand was that the construction contracts are all about risk allocation and that the risk ought to remain with the party who is best placed to manage it in order to achieve a commercial value. Failure to allocate a risk correctly results in huge expense. Unfortunately, this absence of understanding of the narrative of risk allocation went unchecked, and the PWC, that's the Public Works Contract, was introduced for all public works projects. Mr. O'Brien continued his explanation that the objective of the Public Works Contract was to ensure fixed lump sum contracts which would provide cost certainty. Although the price of the tenders under this new form of contract were expected to be slightly higher than those tendered under the previous government contracts forms, the objective of the PWC, the Public Works Contract, was that there would be no other costs attached to any project. O'Brien further explained that whilst the PWC's fixed lump sum contract price seemed great in theory, the politicians who initiated the drafting process did not fully grasp the mechanics of the Irish construction industry, and that there were some very real problems with the PWC. The first problem, as Mr. O'Brien correctly pointed out, was that these forms of contract were untried and untested, as nowhere in the world used these forms before or anything like them. Whereas the GDLA and the IEI forms of contract were based upon their UK counterparts, meaning that parties to projects under these forms of contract could see that such contract worked in the UK, the entirety of the new PWC had no procedure form or no precedent form which parties could derive any interpretive certainty. And this problem remains today. I would point out that this problem has been exacerbated by the first fact that the PWC has been amended no less than 14 times since its inception. The second event that Mr. O'Brien refers to is the global financial crisis of 2008. This stunted any meaningful assessment of the PWC, so it was impossible to establish whether or not it actually worked. The third event that Mr. O'Brien refers to as part of his description of the storm is the effect of the introduction of the 2010 Arbitration Act, which he says made the situation even worse due to the fact that the case-stated procedure in the 1954 Arbitration Act that applied until then was abolished, and therefore no one could obtain judicial interpretation of what the individual clauses in the PWC meant. O'Brien insinuates that this may be due to the drafters of this act not giving full consideration to the use of the PwC, where there was no authority to assist in the interpretation of the clauses therein. The 2010 Act effectively erased any chance that the construction industry had of creating a case precedent for the PwC. The final point that I would like to take from Mr. O'Brien's article is his reference to the revisions to the PwC, of which there were many more than 14, sorry, I should say just over 14, of which had the exactly problematic effect, extreme problematic effect. He gave the example of the amendment in version 1.4 on 28 July 2011. That amendment stipulated that each party would pay their own cost in arbitration, regardless of which party effectively wins. This was enabled by Section 21 of the 2010 Arbitration Act, with the removal of the prohibition on contract terms, which makes parties liable for their own costs in any event. This amendment is considered to be hugely inappropriate and inequitable to be included in a form of contract drafted by the government, particularly as it directly contrasts with the superior court's rules where costs should follow the event. Getting back now to the main theme of my presentation, the dispute resolution mechanism under the PwC, when it was first introduced, was conciliation followed by arbitration. With the introduction of the Construction Contract Act 2013, which came into force in July 2016, statutory adjudication became another step that had to be included in the PwC. Despite there being over 14 changes made into the PwC, no dispute avoidance mechanism was included alongside the dispute resolution mechanism I explained. So conciliation may be adjudication followed by arbitration. As such, dispute avoidance, which is part of the DAB procedure, was no longer in use in Ireland since the introduction of the PwCs in 2007. And the experience of the FIDIC contracts that I explained at the beginning of my presentation appeared. It was in 2015 that the third stage of the Lewis project, the Lewis Cross-City project, that was extending the Lewis to the northern part of the city. It commenced and had to use the PwC. The main contractor in this stage of the project was one of the main contractors in the second stage of the Lewis project, and although the employer had changed its title, it was effectively the same employer as in the first and second stages of the Lewis project. Having been aware of the advantages of dispute avoidance that were implemented through the DAB procedure in both stages of the project, the first and the second, they wish to have a similar procedure in their contract superimposed on the PwC contract. Having been the sole standing DAB on the first and second stages of the project, I was then invited to participate in a discussion on how this might be done. This discussion resulted in a creation of the position of a standing conciliator, and a new set of rules had to be drafted for the use of that position. The project was substantially completed in November 2017, and although it was a very complex project with many difficulties as it involved many civil engineering works in the middle of a busy city center, all of the problems were resolved using the mechanism of the standing conciliator and without any reference to arbitration. Due to the success of the idea of the standing conciliator, the drafters of the PwC picked up the idea and attempted to implement the principle of the standing conciliator and in a similar role to a project board. But unfortunately, they failed to implement the essential parts of the rules that we used and we developed in the standing conciliator by the third stage of the Lewis project. The main problem was that the dispute avoidance mechanism must begin from the very start of the events that had to be leading to a dispute. Now, can I ask Jared, please, to show the slide that I have on the dispute resolution or the mechanism of the dispute? Jared, can you please?
I will. I think Anne is going to share and Russo is going to share the slide. If that's okay, Anne. Here we are. Thank you, Anne.
Thank you. As you can see, a dispute doesn't just come about in a day. It starts, and I call this process the manifestation of a dispute. It starts with a recognition of a problem, a recognition or the emergence of an issue relating to an event or circumstance that would have happened on the project. Then that recognition, if it's not resolved, becomes an accusation, argument, and potential disagreement regarding responsibility and liability. And of course, in here, I'm using the two terms independently of each other because they mean two different things. Now, the argument and the potential disagreement, if not resolved, would lead to a disagreement. And that is the creation of a conflict with intensity. When the disagreement is not resolved, then we end up with a claim. And the technical definition of a claim is it's an assertion of a right, money, time, or a remedy. The assertion may be put in a forceful form as an assertion, or indeed a polite form of a request. But when the claim is rejected, and when that rejection is rejected, only then that we end up with a dispute. That is the technical term of a dispute, the legal term, I should say, with a dispute. Of course, that legal definition has been commented on in various cases, and this would be important in realizing the importance of that manifestation of a dispute. So, in order to come up with a solution to our problem of avoidance of a dispute, we must catch the problem when it starts. It's too late to avoid a dispute when a dispute has arisen. I would say even it is too late to catch the dispute and eliminate it even at the time of the claim, because here we have assertions and cross assertions. I would say then that the avoidance of dispute must start from the very beginning with the recognition. When the problem is recognized, that's the time to avoid the dispute. Or even when it goes further to accusation, or even further, that's probably, in my view, the latest time when you can catch the dispute and avoid it. It is the disagreement. So thank you for the slide. Now I return back to my paper and I say, in implementing the standing conciliator's idea and the project board, the drafters of the PwC issued guidance notes to accompany the PwC. The present guidance note is referred to as 3.11, dispute resolution, which, although expressing the correct sentiments of dispute avoidance, failed to show a proper procedure for achieving a successful avoidance, failed to catch this third or the first three steps in the manifestation. And now, if I may go to that note, that guidance note and show you where that intent is there, is correctly stated, and then refer to the problems that are created after the intention. Now, if you can read with me, it is part 2.7. No, it's the previous part, previous page. It's page 14. Yeah, if you go down the standing conciliator to 2.7, the effect of adjudication. Okay, sorry, gone. Then the numbers must have changed. Between your version and my version, you can see the problems we have. This is a wonderful part of the presentation because you can see now I have a version and Jared has another version. And I don't know how this happened. But anyway, so you were right, Jared, or to put 2.8 on the screen. Now, if you go to the fourth, yes, indeed, where the hand is, the intention behind the introduction of the standing conciliator, that paragraph is very well done. That intention is absolutely right. But then when you go down to the next paragraph to say to ensure the standing conciliator can fulfill such a role, the parties should, and this is where things go wrong. The standing conciliator shall be issued with a complete set of contract documents. Okay, I'll accept that that may be important at the very beginning. The standing conciliator shall attend site on regular basis, yes. But then the standing conciliator shall be included on correspondence surrounding clauses 4.9, 4.10, and 4.15 from each party. Now, 4.9 refers to the program, 4.10 refers to the progress reports, and 4.15 refers to meetings. That have nothing to do with it, with the dispute yet. These are only necessary if they become part of the dispute. There's no point in hampering the standing conciliator with hundreds of documents continuously thrown at him for no reason. The very first manifestation steps, these shouldn't be important. Thank you. Now let's get back to this, and then you look at clause 13, which is now the conditions of contract. It says in clause 13.1.2, the dispute management procedure for resolution of disputes arising under subclause 10.5.4 and 10.5 or 10.55 of the contract consists of meetings of the project board as detailed in this clause. Now, I don't have time to go through all of these detailed procedures. All I can tell you is what clauses 10.5.4 and clause 10.5.5 of the contract are really important only because an employer's representative has issued his determination. Well, now that's the dispute. So if the standing conciliator can't come in before then, you have done nothing, absolutely nothing for avoidance. Too late. You've spent money down the drain and absolutely nothing to show for it. And therefore, what goes in clause 13.1 about the project board meetings and how it meets and the rules about the meeting is only wishful thinking. There's absolutely nothing to do with dispute avoidance. So if you want to go further into this, unfortunately, I would need another hour to explain, but I've given you the essential parts of where the PwC has gone wrong. It's in guidance notes, and it's clause 13.1 and 13.11, 13.1.2, because it hasn't dealt with the dispute before it became a dispute. It is dealing with a dispute after a dispute has arisen, and that's not avoidance. So what about the future? Well, what needs to be done now is to either properly adopt the mechanisms of the standing conciliator that we used, or else properly incorporate that mechanism into contractual adjudication. Of course, there's no problem in having contractual adjudication alongside statutory adjudication, but I will leave those ideas with Jared to see how he actually adopts them, if he does. On a final note, I believe that at present, a firm of consultants, Indicon, has been appointed by the Office of Government Procurement to investigate the operation of the roles of the standing conciliator and the project board, with the view of updating national policy in dispute avoidance, and I wish them success and every luck. Thank you very much for listening to me, Jared.
Thank you indeed, Niall, for that. That's certainly a very comprehensive introduction, and you've set the scene nicely there for us. There's food for thought, and we'll certainly come back to many of those topics. I think the fact that the Office of Government Procurement have launched the review of the project board and standing conciliator process does offer the opportunity perhaps of looking at the dispute avoidance stages and dimensions in a greater degree, and I'm confident that will be taken up. I'd like to ask Aoife to speak to us now on the topic of the theory and the practice, and pick up on some of the themes that Niall has spoken about, and we'll come back to a Q&A session and a roundtable upon completion. So Aoife, I think you're unmuted, are you?
Yeah, I am on mute. I was listening intently to Niall and wanting to not disturb. So thank you very much, and thank you for having me. And good evening, everybody that is, or wherever you may be. I think it's evening in many places that may be listening to us today. Just I learned a lot from listening to Niall now about the Irish experience, and I can draw some interesting points with Niall was mentioning the third stage of the Lewis project, and talked to the fact that the contractor and the employer in the third phase were the same as the second phase. And they adopted the standing conciliator the way they understood it and the way it had worked for them in the second phase, and they adopted it successfully, and nothing went further to arbitration. I think this is an experience that is shared widely around the world. Anecdotally, when employers and contractors realize the benefits through experience of using a DAB and have success, that breeds further success and further employment in adopting the dispute boards. And what I'd like to do is share a little bit of the FIDIC experience of the growth of the dispute boards, the use of dispute boards, and in tandem talk a bit about the ICC experience in using that, and then going full circle and relating it back to the commentary that Niall brought up on the Irish experience. And one of the key features that Niall has already mentioned, a key feature of dispute boards can be the avoidance of disputes. But that's the theory. The practice is that the dispute avoidance can only happen when certain parameters or when certain items are met. First, it has to be a standing board. FIDIC, like Niall had mentioned in 1999, employed a standing board in the Red Book, but ad hoc dispute boards in the Yellow Book and the Silver Book. What was found is if the dispute board was constituted in a timely manner with thoughtful selection criteria set out by both the employer and the contractor of the characteristics and the experience and the qualifications of the dispute board members, and allowing intervention at the right time. And when I say right time, I refer back to Niall's dispute evolution cycle or dispute manifestation cycle. When a dispute has already crystallized and parties are positional, it's much more difficult to unravel the issues. The earlier that intervention takes place, as close as possible to the issues surfacing, and having constructive communication around the issues, that was found to be a way to actually avoid the escalation into a dispute. Then so what FIDIC did, fast forward in 2017, we see now that there's a standing dispute board employed in the red, yellow, and silver. So ad hoc is no longer used. And the characteristic of an ad hoc dispute board is that it's constituted after the dispute has arisen. So once you have a dispute, you have dispute resolution. If your objective is dispute avoidance, your intervention must be earlier in that manifestation cycle, before the parties become positional and engaged with their positions. And this has also been the experience of the ICC dispute board rules. The ICC use of dispute or publication of dispute board rules first surfaced in 2004. So a little bit behind the FIDIC experience. They first published dispute board rules that allow for ad hoc and standing dispute boards in 2004. And then in 2015, they updated, the ICC published an update to their dispute board rules. And in that, it's Article 16 that allows the dispute boards to raise issues with the parties and to provide informal advice. So what they share is the early intervention in the dispute manifestation life cycle, as Niall terms it. And what that allows is addressing these issues early, and then you can actually have dispute avoidance. So what this is it's an investment in the addressing the dispute or managing issues such that they don't turn into disputes in the first place. And I'll quote from, there's always been a controversy having a standing dispute board. It's expensive, the retainer fee is expensive, and so parties are hesitant because it's an expense. I'd rather get my project without this extra expense. And you need to take a step back from that and look at the investment in a dispute board as an investment to avoid the escalation of issues into disputes and avoid the escalation to arbitration. I'm quoting now from a publication from the Japanese International Cooperation Agency, JICA. And they say, on both the daily fee and the retainer fee, it is to be remembered when deciding on fees that the contract parties are investing in the dispute board as a means of trying to avoid the much more costly and time-consuming process of international commercial arbitration or litigation. So with that picture in mind, you are paying something now to avoid a bigger catastrophe later. And I would say that a term I learned from Niall, and it's not surprising that Niall would use the term, that it's similar to insurance. It's an insurance policy. With his significant background, not only in dispute resolution, but also in construction insurance, I think this is a perfect way to view the dispute resolution. So you have to have early intervention, continual intervention or continual engagement of the standing member of this dispute board. And a dispute review board can be a board that gives a recommendation. In FIDIC's case, it's a dispute adjudication board that gives a decision that's binding. But a dispute review board can be, a standing dispute review board can be seen more similar to in my view now, in hearing about the Irish experience of the standing conciliator, that a dispute review board is very similar to, or can be more similar to, a standing conciliator than a dispute adjudication board, because the ultimate output of a dispute review board is a recommendation similar to the conciliator. And now with the enhanced ICC rules, a dispute review board, a standing dispute review board, can also engage the parties to facilitate avoidance of disputes. But the key of that is early intervention in the dispute resolution cycle. So when we talk about theory and practice, I think I'll go back to the Irish guidance notes on dispute resolution that Niall had put up just now. And it was on page 14 and to the article 2.7. I might have Niall's copy that I downloaded from the internet. I saw 2.8 and 2.7, but I have page 14 and it's the standing conciliator article 2.7. And from the same paragraph that Niall was reading from, it talked about the intention behind the introduction of a standing conciliator is to encourage proper engagement between the parties, to assist the parties to avoid disputes. And that, as Niall said, starts really well. But what do we need to avoid disputes? We need a means by which to identify issues and escalate them to the attention of the parties and have constructive dialogue to address the issues and resolve them before they escalate into disputes. And this same paragraph continues to read, it says, if a dispute arises, the standing conciliator will act as a conciliator within the meaning of 2.7.2 of this guidance. So the standing conciliator is not only engaged, is engaged to act when the dispute has arisen. He or she is employed as a standing member, so you got that part right, but isn't authorized to act until the dispute has arisen. And that is too late to avoid a dispute, because the dispute, you can't avoid something that's already there. You've already encountered it. You may be able to resolve it. You may be able to resolve it. You may be able to facilitate some dialogue and party agreement to resolve it, but you can no longer avoid it. And I think that's where the realignment of theory and practice needs to come together to be able to achieve the intentions, as stated. So the kind of realigning the procedural machinery with the dispute manifestation life cycle in an effort to better achieve the objectives as stated. So with that, I'll stop there and turn it back to you, Terry.
Well, thank you very much, Aisha, for those comments. They're very, very informative and very, very useful. I think that what I'm taking away from both of your presentations is that early intervention is key, really, in terms of the success of a DRB, a DAAB, or the standing conciliation process as we have it in Ireland, in the context of what the guidance notes, the objectives set out in the guidance notes themselves. I mean, just by way of a bit of context, the National Development Plan in Ireland, there was a report published during the week on behalf of the Department of Public Expenditure and Reform, where they had consultants EY looking at constraints and capability issues within the market to deliver major projects. So between now and 2040, there's I think it's 116 billion euro to be spent on major public infrastructure projects: water, roads, bridges, rail, wind, renewables, etc. And that report pointed to constraints in a number of areas, capabilities, but it's clear that the time taken up resolving disputes within these contracts is a real constraint. It's distracting, it's time consuming, it's bad for relationships, it's distracting our engineers and our designers and our constructors away from designing a proper piece of infrastructure that they should be doing towards time consuming, non-productive resolution of disputes. And I think that is wrong. And I think the report was timely. And I think that the activities of what we're doing tonight in terms of the DRBF are timely in terms of what we may be able to bring to the table in terms of standing conciliation or otherwise our dispute boards in Ireland. So that's the context. If I might just turn to you, Aisha, particularly in terms of the FIDIC approach in the 2017 forms and the DAAB, so that's Dispute Avoidance and Adjudication Board. Bit of a mouthful, but we know
it's a mouthful. It's a DAB.
Clause 21.3, I think it is, of the 2017 form specifically talks about the avoidance of disputes and the mechanics there. And maybe you'd initially, from your own experience as a DB member, talk to us about that, what that actually entails, if you would. And secondly, if you would give a comment as to the what I call it, the perils perhaps of the dispute board members acting in an avoidance guise in one instance, meeting the parties individually or in joint session, versus having to possibly go into a formal contractual adjudication process under, is it clause 21.4, I think, down the line. Is there a perils for an adjudicator there, if you would? Well,
okay. I think first of all, what I would like to underline with 21.3, it is now a separate subclause, which is talking about avoidance of the disputes. And what this allows for is for the parties to jointly approach the board, the DAAB, to get an informal opinion or seek advice. Although this is here as its own subclause, this is the idea of dispute avoidance is not new to the DAB function. It always existed in 20.2 in the FIDIC 99 Red Book suite, but it was kind of lost in the seventh a small sentence in the 7th paragraph. So the parties can approach the dispute board either in the 99 Red Book or under 21.3 to seek assistance informally and discuss in an attempt to resolve any issue or disagreement that may have arisen between them during the performance of the contract. And I think this is key to Niall's manifestation life cycle. It talks about the DAB to provide assistance and or informally discuss and attempt to resolve any issue or disagreement that may, so it's not a dispute yet. And so it allows that informal assistance, or discussion. Now, you raised a point of what do you mean by informal assistance? What can one mean? And it goes on to say, such informal assistance may take place during any meeting, site visit, or otherwise. However, unless the parties agree otherwise, both parties shall be present at such discussions. Now, what this allows to have happen is that you can seek and obtain the parties as a dispute board member, seek and obtain the parties' agreement that you can meet individually with the parties to seek to break deadlock or to better understand the issues that they don't feel like disclosing or are not in a position to disclose fully to the other party. Now, the difference between FIDIC and the standing conciliator in Ireland and the dispute review board is the dispute avoidance. The first A is avoidance, so you're under 21.3. But the second A is adjudication. And once you take off that facilitation hat and don the decision-making hat, then you really are now entering into an adjudication function where due process and procedural fairness are a prerequisite. And this same discussion happens around being a mediator who takes off the mediator hat and dons an arbitrator hat. And sometimes when parties don't like the decision that they receive, they say, the adjudicator, the decision maker was biased. They made the decision based on information that I didn't have any insight to. They spoke to the other party independently and didn't fully disclose any of that information to me. And they made the decision. So you're just opening yourself up to possibilities of protest or parties' objections to the absolute unbiased fairness and with due process that decision is made. If you are able to resolve, so it facilitates, if it facilitates resolution, and sometimes meeting with individual parties helps to really unblock an issue and helps to resolve the situation, and you can avoid the dispute. And in that case, it's a very useful tool. But if you're unable to resolve the dispute, and then you must proceed to decision making, it is the dangers or the risks, may I say, of appearance of bias, the perception, because at the end of the day, the parties have to perceive you as being fair as well as you being fair. And that is where this wouldn't happen. This isn't an issue so much with the Irish situation, because a conciliator renders a recommendation, and which is only, if it's accepted, then the parties comply. If they reject it, they're not bound by it. But an adjudicator issues a decision by which the parties are bound.
Okay.
Sorry, long answer.
No. Fantastic. Thank you for that. Niall, would you care to comment on that, or would you have an opinion on that issue vis-a-vis the dichotomy of avoidance versus subsequently acting as an adjudicator and the risks that might be involved there?
Well, really, you have to think in terms of the cost saving of the consequences of ending in a dispute. Because if you go to a dispute, then what else do you have? You either have conciliation, adjudication, which is only temporary, by the way, because the losing party may be able to go to arbitration or to the court, or to arbitration if there's an arbitration clause, or to court if there's no arbitration clause. Cost of these escalate incredibly. So, for example, an arbitration, which is, if you have an arbitration clause, this is the ultimate solution, then could last in a complex dispute. And I would say civil engineering disputes are very expensive disputes, very complex disputes. You could end up in 4 years. 4 years of having to pay the law agents, the lawyers, the barristers, the experts, the arbitrators, and so on, and the time lost of 4 years. If you choose the adjudication, then it's also another area where it's going to be costly, but it's not even final and binding. If you go to conciliation, and of course, it is less expensive, more quick. But again, it is expensive from the time you have to spend on from your own resources on the whole process.
Yeah.
So really, the point that you make is that, or the reply to the point you make, I would say it involves cost, and it involves time. And to save all that, then the only choice you have is really to avoid it. How do you avoid it? Then FIDIC has a certain set of rules in its 2017 forms. Standing conciliator had various rules established under the Lewis III. And I would say that you have to avoid these costs by going to dispute avoidance. Now, if I may use this time that you've allowed me to interject to say that I thank Mr. Kevin Burke, who put up a note to say he confirmed that my views were correct, and also Mr. Adrian Griffith, who asked for the title of Mr. Raj O'Brien's paper, and that was published. That was published in Construction News on 3rd February 2021, and there were questions from someone else on the cost of the DAB and how do you convince a client to use the DAB, and that really applies to your question. That's why I chose to bring it up now, because the only way you can convince a client to use a DAB is by pointing out the costs that he would have to pay or use or do something with in order to resolve a dispute. To avoid a dispute, you save all these costs. Let me give you examples. In one arbitration, the award after claim and a counterclaim were resolved. It was only £950,000 sterling. The costs had reached 16 million. This is the kind of money you're talking about. There are very few disputes that, as an arbitrator, and I've done 166 arbitrations around the world. There are very few arbitrations that end up in cost less than few million, not few 100,000, few million.
Yes.
So that's the kind of money you are saving. And the idea that Aisha brought in that kindly refers back to me, and that is use these as an insurance policy. Why do you take insurance? You take insurance in order to avoid a calamity. And this, you must take that cost as an insurance policy to avoid the calamity of eventual cost.
Very good. Thank you, Niall. Just a comment for myself, I guess. It appears to me from what I've heard this evening, returning to the standing conciliation process, and from what I know myself, my own experience of it, and from the guidance notes, that the template or the intent is certainly there towards the avoidance of disputes. I'm taken by the comment you made, Aisha, that it's perhaps more akin to a DRB than a DAB, which it's something I hadn't considered before, but when you say it appears correct to me. So I believe that the number of changes that might have to take place to the standing conciliation process aren't huge towards achieving that aim. Would either of you have a comment on that? The actual changes that would need to be made? I think, Niall, you've touched on them already, really, haven't you?
That question. Sorry, go on.
Sorry, no, I was trying to figure out who was going to speak.
Either Aisha, if you want to make a comment?
I'll go just very briefly. I think the fundamentals are there with misalignment.
Right.
And so I would agree with you that the changes are not insurmountable, and they're not a huge, starting a hammer and champy, starting with a clean sheet of paper. Yeah. It is rather an adjustment of the theory of what you want to achieve, your intentions, but keeping in mind that dispute manifestation life cycle and the point of intervention to achieve the objective or intention of dispute avoidance.
Thank you, Aisha. Niall, do you want to speak on that issue? You've spoken.
Well, the only thing I would say is that, in my view, a mix between what a DAAB under the FIDIC 2017 and the rules that we initiated and wrote in the Lewis 3 should be used to mix and come up with an answer to a dispute, to a project, being whether it is international or domestic. For example, one of the questions on the board says the MDB only puts up a 60 days inspection of site. That's not what the MDB says. The MDB gives a maximum of 60 days. It means, remember, the MDB relates to an international project. In Ireland, it's very simple to go, for me, 10 miles to get to the center of the city and inspect. So the inspection was more usual at 2 weeks. And the international contract could be a maximum of 60 days, but certainly it could be introduced at an earlier stage. So these are the points that I would like you to consider for the future in Ireland. Consider for the future a mixture of DAAB contract. Consider that with the rules that we invented in the Lewis 3, and see what you can come up with. Maybe you can get rid of the contract at the moment. I think that would be a horrendous task. But if you can't, then for the ordinary contract, okay, use the public works. But for specific contracts, vary it. Use the FIDIC contract, which allows, or use something similar that would allow a DAB in, and then find out whether the DAB rules in there would be implemented or complemented by the rules that we invented in the conciliation process we had. But certainly what I'd like to emphasize is that what we have now under the public works contract is neither a dispute avoidance mechanism, nor it is a standing conciliator. They borrowed the name, but they didn't use it rightly.
Okay, thank you, Niall.
I would also, just to add to what Niall said, is also look at the ICC Dispute Review Board rules, because they may be useful for thought-provoking especially when you're undertaking change.
Absolutely. Thank you for that, Isha. That's great advice. And I mean, one of the things that I want to do as the country representative is to be a voice in terms of how these things could be improved in terms of standing conciliation or otherwise, and that the form of contract that could be used as Niall says. Yeah.
Just if I may interject there, the only reason why I didn't refer to the DRB, which is a review board, is because really it doesn't fit within the mechanism of determination and the decision making. It gives a recommendation, and the recommendation fits in with the conciliation idea. But the idea in here is not, it's a decision. Under the under the FILIC contract, you need a decision making. Under the public works contract, you need a determination, which is in the form of a decision. But there's no recommendation in there. That's the only reason I didn't use DRB. But I agree with Aisha that we should look at that, whether you can come up with somewhere in between.
Okay, thank you, Niall. I might just, we're 6:10 now. I might just turn to some more of the comments and questions that have come in, if I could. There's a question for you, Niall, from Tim Ahern. Can you read it? What I call it?
No, I don't. Let me see if I can get it. It's from Tim.
From Tim at 5:43. I can call
It's
it
under the Q&A, Niall. It's not under the chat. So if you press if you press the Q&A button.
Oh, the Q&A. Okay. Let me press that. Tim Ahern. Yes, I have it now. PwC recommendation is temporarily binding, subject to referral to arbitration. And that's really why I need. Tim is absolutely right, and I'm glad he's well and able to join us. But he's absolutely right. But that's the reason why I said I need an hour to explain all the problems in clause 13. And Tim points to the very essential problem in clause 13. But there are many others. There are many others than the one that Tim has mentioned.
Yeah, absolutely.
And then there is another one before it. Tim,
yes, that's the one I was referring to earlier.
Would it be fair to suggest that PwC fundamentals is that it had got things wrong on standing conciliation? Yes, it has. And on public, well, yes, it absolutely it has. Paragraph 27 of 311 allows standing conciliator to engage the parties, but not with the project board. This is a ridiculous statement from the board and from the conciliation. And Tim points out absolutely rightly that that's a big problem. But again, I need an hour, maybe now 2 hours, to explain all the problems in clause 13. Is there any other questions?
Jerry, we have a comment to Jerry that the audience cannot see the questions. So it might be good for us to read what the question is.
Okay.
And then particularly the one that Niall has already answered from Tim, just so that the audience that isn't as familiar can follow this.
Yeah, I'll read it out. I'll read it out, certainly. So it goes to Tim Ahern. Niall, would it be fair to suggest that the PwC fundamental is that it has got things wrong on standing conciliator / project board relationship?
Yeah.
Paragraph 3.2.7 or 3.11, which is the guidance notes, allows standing conciliator to engage with the parties, but not with the project board until a dispute exists. Too late is what Tim is suggesting. Should project boards be eliminated and keep standing conciliator? So that was the question. I think you've spoken to that.
Well, if I may interject again,
yeah,
in here, then it is my question to myself that I can explain it. And the question is, where does the where do the rules now go wrong? And I would say, if you look at clause 13 of the contract, of the works contract, and you try and match it with what the guidance notes say as to what the conciliator, standing conciliator, has to do, everything's wrong. For example, it says, well, for example, I tell you what, in my view, the standing conciliator should be. Standing conciliator should be the chairman of the project board. He would drive the dispute board to get to him the manifestation of the dispute. He would have to tell them. Not everybody knows my slide about manifestation of dispute. He should instruct them as to what his function is and what they have to do. And he should chair the meeting. He should direct what they have to do. They have to come to him when they are in need, but he has to instigate that by asking questions. And the meetings of whatever days it is absolutely wrong, too long, too late. And that's really why I answered the question about the meeting under the NDB. That's not to do with dispute avoidance.
Sorry, Niall, to interject. In 2.7.5 of the Irish guidance,
yeah,
the first bullet point says the standing conciliator may, with the agreement of both parties, chair or be invited to attend the project board meetings. So
exactly.
It's like, it's all possible, it's all there. And this is back to Jerry's point.
It shouldn't be may. May is wrong. Standing conciliator must chair and direct and instigate and inform and tell and teach the people on the board, because these people, they come from the different roles of a construction.
So you might want to start there as well at 2.7.5 and look at the relationship between the standing conciliator and the board. So not only the intervention point,
yes,
but the relationship and the interface between all the functionaries.
yes.
Yeah. Okay, now I'm going to increase my time to 2 hours. If you give me 2 hours, I would then tell you what's wrong.
Now, we have another question in on the topic again. You can probably read it there. It's from an anonymous attendee. It's a long question. I might just read it out for the benefit of our participants that can't see it, if that's okay. So it goes, Niall's presentation appears to conclude that the standing conciliator role in the PwC does not allow for dispute avoidance because the role is only referenced under clause 13.1 of the contract, conditions of contract, i.e. when a dispute crystallizes. And the question is, does the fact that the parties are given the opportunity to appoint the standing conciliator on their own agreed terms not in fact allow whatever interaction they want the standing conciliator to have in dispute avoidance, i.e. they can agree to have the standing conciliator interject, assist at the point of recognition of an issue, if they so wish. There is a template form provided in the Capital Works Management Framework which allows the party to include whatever terms they want and also allows the standing conciliator to suggest terms of engagement. If this is not apparent as the method by which the standing conciliator role allows for dispute avoidance, then hopefully the review of the roles currently ongoing will point this out. So it's a question and a comment there, Niall, if you'd like to.
Well, I mean, I would say, again, unfortunately, I need time to explain all that. The idea behind the correct idea behind the standing conciliator is that he would then direct the parties that whenever the first step of the manifestation appears to them, they should come to him with a letter or something to say, this has arisen. If he thinks that that can be resolved by correspondence, he should. If he doesn't, he calls a meeting. And at the meeting, he would explain what he expects to be done. And basically, it would be very simple. He has representatives from both parties. Those representatives should be asked to give in 1 page or half a page or 1 paragraph, depending on the problem, explain why they think they're right and why they think the other side is wrong. That may instigate the way forward to stop the first step being a second step.
Yes.
Let me give you an example of what happened in Lewis 3. In Lewis 3, I caught something up at this stage, at the second stage, when there were accusations. and the designers of one side disagreed with the designers of the other side, and they both called the others incorrect. Now, being a consulting engineer myself, I knew that I could deal with the design. So I asked, it was designed to do with the retaining wall. And I said, well, why? Why do you think this, you're right and the other side is wrong? And I got the answers from both. And believe it or not, in 5 minutes, I found out that they are crossing each other because one was using the American system and the other one was using the English system.
Yeah.
Sorted out, 5 minutes, no more. That would have ended up in a determination with the employer's representative saying his side was wrong. And then it would only be then that it would be referred to the standing conciliator. Well, I can ask you this question. Do you think the employer's representative is going to say, sorry, I was wrong? He's not.
Okay. Thank you, Niall. Just one comment on the question that arose there, and Anne has very kindly posted it in the chat function. I mean, I think the question that the individual that made the comment on the question is quite correct. The standing conciliator can agree in their own terms, and I think the intent is certainly there towards intervention and dispute avoidance. It may be that there's a slight dichotomy between what the guidance note says and the Capital Works Management Framework terms and conditions say, versus the actual clause 13 provisions, which would make a standing conciliator nervous in that space.
Well, if you're suggesting that you use the present clause 13 and the present guidance note, I would say you're wasting your time.
Yes.
You really must start from the beginning.
Yes, I think that's
both of them are wrong, terribly wrong, and cannot be used. Tim Mahan pointed out to another problem, for example, in clause 13. I can point out to another one that caused us tremendous hassle. I was chairman of the Engineers Ireland Committee on Dispute Resolution. And we had to sort it out by trying to explain what the contract meant. And we used it. It wasn't right, but we used it and nobody said no because they knew there's no other answer.
Yeah.
Now, take the question about the bond. The bond. How, if you are going to get 100,000 euros from a recommendation, then having to give a bond of 100,000, what benefit are you going to get? Nothing. How do you solve that one? You know, it's a amalgam of problems.
Okay. All right. Well, look, we won't solve them all tonight. I think we've gone some way to point out where the potential resolution may lie. And obviously, as the questionnaire has pointed out, the office, and you point out yourself now, the Office of Government Procurement are engaged in a review of the Standing Conciliation Project Board role. So we'll all engage with that process as best we can. We're close to 90 minutes. I wanted to pose a question to you, Niall. I picked up during your presentation, you mentioned statutory adjudication and under the Construction Contracts Act 2013 and the potential for contractual adjudication under a DRBF.
Well, what I meant really by that intervention or by that comment in my paper, in my presentation, is that you could use a DAB or a DAAB under the contract, as well as the statutory adjudication.
Yes.
Statutory adjudication is a right that you've been given as an Irish citizen. And that you have to look at it separately. Now, in order to employ either a DAAB or a standing conciliator, call it what you like, you bring it alongside the adjudication. And of course, there's a huge difference between conciliation and adjudication, huge difference. And on Saturday morning, I give my lecture on that to Trinity students. It takes 3 hours. So do we have 3 hours? And that 3 hours could only deal with the difference between conciliation and adjudication. There is no way I can tell you in 2-3 minutes time. There's a huge difference, all I can say.
Okay. So food for thought there. Look, it's been a very interesting evening. I wanted to thank the speakers, both speakers, most sincerely for their thought-provoking comments. I think that the message that I have taken from it is on a practical terms, the early intervention within the dispute manifestation cycle is key, and to consider the DB or standing conciliation process, albeit that it's maybe in need of some tweaks, as an insurance and not a cost. So I think that's two fantastic pieces of learning that I've taken from it. The other thing I would say is, the work goes on with the National Development Plan in Ireland and otherwise. These issues need to be resolved and will be resolved. And I think it's an exciting time for members of the DRBF, and for me personally as the country representative, to be involved in the process and trying to make these processes more streamlined and better and more efficient, and to really press the benefits of dispute boards to the Irish audience. And I would encourage any of our participants and our attendees that want to get involved with the DRBF to check the website, to become members if you wish, and to contact me directly if you have ideas or topics for future seminars or webinars, or if indeed you wish to speak at them. I'd be delighted to hear from you. And with that, then I think I bring this evening's events to a close. And just to say, I think Anne mentioned it at the start that the webinar has been recorded. So within a number of days, the recording, as with all our recordings of the DRBF, will be up on the DRBF website. And with that, thank you very much all, and good evening to you all. Thank you.
Thank you, Jared.
Thank you. Thank you, Jared. Thanks to DRBF for inviting me to
Thank you. Thank you, Anne.
presentation.
Thank you, Anne, and thank you to the DRBF, and thank you, Niall.
Thank you. Good evening.
Thank you all. Bye-bye.
Bye-bye.